Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo. I'm the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. You can enter those questions anytime you feel comfortable. Just know that we hold them until the end, and oftentimes it's not possible for us to get to all of them. If you are pursuing continuing medical education credits, there is a sign-in sheet in the chat box now, so you can click that link to sign in. Similarly, for those that are pursuing APA continuing education credits, there will be a link for the survey that you will complete that will also be in the chat box. That is saved until the end of the presentation. So keep your eye on the chat box in the latter portions as we get closer to the top of the hour. Make sure that you bookmark that link if you don't open it ahead of time, and make sure you save your certificate after you complete the survey, because we don't have access to completed survey certificates after the fact. If you missed last week's talk in the series, Dr. Lenore Walker's discussion of APA professional practice guidelines for working with trauma survivors in clinical and forensic settings is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube page later this week, and the PowerPoint slides will also be accessible for people that have registered for the series later this week as well. As a heads up, next week we have Dr. Maria Apatero-Suedo, who will be discussing competency evaluations in immigration court. But circling back to this week, I'm honored to introduce you to today's speaker, who will be addressing some commonly asked questions in forensic mental health practice. This is Dr. David Shapiro. Dr. David Shapiro is a professor of psychology in the forensic concentration at Nova Southeastern University. He's been involved in forensic work for over 50 years and was one of the founders of the American Board of Forensic Psychology. He has extensive publications in the areas of psychology, law, and professional ethics. This includes 12 textbooks and over 40 peer-reviewed articles, and he has also received distinguished contribution awards from the APA Division 42 and the American Academy of Forensic Psychology. He's lectured internationally on a number of different topics in psychology and law, and has also served on the ethics committees of APA, ABPP, as well as state boards. He's co-authored 2 recent books, Introduction to Forensic Psychology, the second edition of that one, and Forensic Practice for the Mental Health Clinician. So Dr. Shapiro, David, on behalf of the University of New Mexico, thank you so much. We're excited to have you joining our series and thankful that you'll be sharing all of this practical expertise with us today. I'll go ahead and throw it over to you.
Thank you so much, Anthony. Pleasure being here. I've done some of these before and have enjoyed it and the interaction. I'm going to leave some time at the end. Now, you may be deceived by the fact that we only have 4 slides, but believe me, we will be talking extensively about the issues on the different slides. So, Alex, please, let's move. Oh, okay. This is disclosure. Okay. No financial arrangements. They're my views. Okay. Okay. So let's focus in on major differences between clinical and forensic practice. First is the focus. Okay. Clinically, you are focused on treatment. You are focused on that individual. You rarely, if ever, I'll talk about this a little bit more, are going to be seeking extensive collateral materials, outside materials. Your focus is as a helper, okay? Of course, with forensic practice, you are not a helper. You are regarded as an objective, neutral evaluator. Sometimes it's very difficult to shift roles like that. But here are some of the areas that pose some differences. We pretty much all know about informed consent within the clinical situation, although a lot of people, a lot of clinicians either pay very little attention to informed consent documents. A lot of times when I've reviewed these files, informed consent usually has to do with the fee and nothing else. But as we'll see, informed consent consists of a lot of different areas. Informed consent, basically, according to our ethics code, it really reflects or is largely concerned with the sufficiency of information, and to a lesser extent with limits of confidentiality, though that is also an important one. But even in places where there settings where there is no limit of confidentiality, informed consent means you always have to let the person know who you are. You know, that is sometimes so simple that people will overlook it. How is it that this, let's call it an evaluation, comes about? Were they sent by a court? Were they sent by an attorney? Are they coming on their own? What is the nature of the referral? And the fact that depending on the setting, you may or may not be bound by confidentiality. So for instance, in doing forensic evaluations, it's always important to tell someone that the traditional rules of confidentiality do not apply here, because what goes on in this forensic evaluation will result in a report. Depending on the state or jurisdiction in which you are practicing, the report may be distributed to different individuals. You have to tell the person what this contact will consist of. And again, focusing on the evaluation and what it's for. Let's say a competency to stand trial. You say, this is going to be an evaluation of your competency. If you don't understand that, let me tell you what it has to do with, that you understand what is going on in court, that you're able to work with your attorney, things of that nature. Okay, that is and then you get into issues of confidentiality and limits on confidentiality. So that is what is called the sufficiency of information prong of informed consent. The second one, which a lot of people overlook, is competence. Now, we're not talking about competence within although it may also apply to a forensic setting, but we're not talking about competence as in competence to stand trial, competence to enter a plea, these various kinds of competencies. We're talking about competence to give consent. And you generally find this out by, after you inform the person of these, ask them to repeat back in their own words what it is you just told them. And sometimes, unless the case is court ordered, you may have to stop right there. If they have no idea or cannot comprehend, the limits on confidentiality, the people to whom the reports will go, you will need to stop and consult with that person's attorney. The attorney is able to give what is called substitute judgment, which legally means, what would the patient do or client do were they competent? And an attorney of record can give that, but you do not, under any circumstances, without that intermediary step, proceed with an evaluation. And then finally is voluntariness. This is the third element of informed consent. Given all of these matters that were just discussed, are they willing to proceed with whatever the process might be? Okay, a few words about differences in confidentiality and privilege. I assume you know the difference. Basically, confidentiality is a basic ethical principle about maintaining in confidence, maintaining privacy over what is being said. Privilege is a corresponding legal concept, and privilege deals with what happens to the concept of confidentiality once you're in a legal setting. Okay, now, there are different kinds of privilege communications. And all states, well, basically, every jurisdiction recognizes both of these. And one is called psychotherapist patient privilege. Notice it's generic. It does not apply just to one mental health profession, but psychotherapist patient privilege, which again is the assumption that what happens in psychotherapy is confidential. The confidentiality, or more precisely, the privilege in such circumstances has a lot of exceptions. Okay, this is an important thing to note if you are looking at the differences between these two. First of all, as I'm sure you all know, there are mandatory reporting obligations in certain kinds of situations, such as child abuse. Where I am practicing right now in the state of Florida, because of the large senior citizen population, we also have mandated elder abuse. And it can be very broad or very narrow. Some states even recognize mandatory reporting of emotional abuse. So be very clear when when you're in any state that you are, exactly what the exceptions for mandatory reporting are. The second is it's sometimes called the patient as plaintiff. So if one of your therapy patients puts what is called their mental state into litigation, in other words, they are suing someone for mental or emotional damages, then your records may be subject to legal discovery. So somebody can't assert that, say, they have post-traumatic stress disorder as a result of an accident or injury without the possibility that the other side, the side being sued, the defense, will ask for your records. Okay, why do they want the records? It's a matter of cutting their losses. If they can establish the fact that you had, or your patient had, all of these conditions previously, then the emotional condition that they are alleging right now, they may say, well, it's just a minor exacerbation of something that pre-existed. But you can see why they want the records. And this may raise a really serious ethical dilemma for therapists, because they may have a great deal of material that they don't want to reveal, or that the client or patient does not want to reveal. Well, there is a sort of a helpful phrase in there. This legal discovery, the discovery of your records, courts have ruled that what is discoverable is anything that is relevant to the litigation. Now you can see the next dilemma: relevant to whom? So you and your patient or client may say, well, only the symptoms that I have been experiencing since the time of this accident or injury. And the other side, the defense may say, no, all of the records we want revealed, again, because we want to look at the possibility of pre-existing causes. How does it get worked out? Ultimately, by a judge, what's called an in-camera hearing within chambers. The judge will rule whether the information that is being sought is more probative or more prejudicial. Probative means essential to the case proceeding. Prejudicial would be harm to the client, harm to the whole enterprise of psychotherapy. So, you may be faced with having to justify why you don't want to turn over certain records. But courts generally bend over backwards to admit all possible information. So if there is a really strong reason why you as a therapist don't want certain material released, that is something you obviously need to discuss with your client, and you prepare a document to that effect. Okay, so that is the patient as plaintiff. We're not done. There are a lot more exceptions. If you are concerned about a patient's danger to self or others, there is, of course, the possibility of involuntary commitment. And your evaluation of whether or not they fit the criteria of being a danger to self or others by reason of their mental disorder, that report has got to go to somebody, to the police, to a receiving hospital, to some third party. So obviously that is not regarded as privileged information. If you yourself are the subject of an inquiry or a complaint or a lawsuit, one of your clients is suing you, then that is also an exception to privilege, because you are entitled to release the records in order to demonstrate that you have in fact met the standard of care, that you haven't done anything wrong. Okay. There is, of course, in many, well, just about all states, well, I think 5 states do not have laws that address the so-called duty to warn or duty to protect third parties. And you notice I talk about the differences because, again, a misperception is that duty to warn is a uniform standard. It is not. It varies dramatically from state to state. Some it's called duty to warn because that's the only intervention that is allowed. Other states have a more flexible standard, duty to protect, where you can basically use your clinical judgment to determine which kind of intervention to make. Some states are what are called permissive, some are mandatory. So before you make some sort of action in that setting, be sure to understand the state law where you are. Finally, some states, not all, but about, maybe a dozen states, recognize what is called the criminal defense exception to privilege. What this refers to is if you are treating somebody who is either a victim of or a witness to a criminal offense, the attorney representing the criminal defendant at trial may be able, I say may, not always can, may be able to access your records in order to cast doubt on the credibility of that person's testimony. Okay. This person is being treated for schizophrenic disorder. They hear voices, they have delusions. Does the jury want to believe that somebody who is delusional or actively hallucinating is or can be an accurate witness? Okay. So these all refer, everything that I've just been talking about refers to the clinical setting. In the legal setting, which is involved in forensic cases, we're dealing with something quite different called attorney-client privilege. Okay, for all of the exceptions to privilege that I just went over, there is really only one exception to attorney-client privilege, and that is that an attorney cannot what is called suborn perjury. If the attorney knows, I guess, or sometimes they should know, that their client is planning to tell a lie while under oath to perjure themselves, they cannot continue to represent that individual. All of the other situations that we described, which are exceptions to psychotherapist patient privilege, do not apply with attorney-client privilege. So this puts a clinician in a real bind, or well, not necessarily a clinician, a forensic evaluator. Because if they are hired by a defense attorney, they are covered by that defense attorney's, it's called under the umbrella. They're under the umbrella of the attorney-client privilege, which means that they have basically the same privilege as the attorney of record. However, they are also bound as psychologists by mandatory reporting laws. And attorney-client privilege, for the most part, there are certain exceptions in some states, but for the most part, that does not constitute a mandatory waiver. So you may have a conflict there. you're a psychologist, and the person you're evaluating talks about involvement in some sort of child abuse. So under your mandatory reporting as a psychologist, you've got to report it. But since you're operating under attorney-client privilege in doing a forensic evaluation, not only don't you have the obligation, you cannot report it. So how do you handle that problem? And it becomes a very, very real problem. Courts have not been terribly helpful on it. There is one case that I'm aware of. In fact, Jeff Youngren brought it to my attention a good number of years ago. A case from California involving just that issue. A psychologist was asked to perform an evaluation and found out that there was evidence of abusive behavior in this person's background. And she was getting conflicting messages on whether or not she needed to report it, because she was a mandated reporter under psychology licensing, but she was operating under the attorney-client privilege. And the court ultimately ruled that the attorney-client privilege overrode, I was going to say trumped, but I'd rather not use that word, attorney-client privilege overrode mandatory reporting laws. I am not aware of any other states that have reached that, nor am I aware whether that issue has been litigated in other states. But it is something that you should always take into account and be sensitive to those kinds of issues. Okay, the fact that they are different kinds of relationships. You know, the one is a helping relationship, one is objective, neutral, impartial, leads to different kinds of methodologies. One is the fact that in a forensic evaluation, you are always seeking out collateral data. You want to check out, say, what a client tells you in the evaluation about their behavior, about their symptoms, whether in fact that has been observed by other people, whether there are reports detailing it. In a criminal case, whether there is any unusual behavior documented by witnesses or family or friends or arresting officers. You'd be surprised what you find in some of these non-clinical sources, just casual observations that in fact have something to do with a person's mental state. So you're always looking at all of these different sources of information over and above your clinical contact with the individual. You will probably be doing extensive psychological testing in a forensic case. First, to give you a wider database, and more specifically, since the question of malingering always comes up in a forensic case, you should have some assessment of the potential for malingering. And here is another reason why you should never mix the roles of forensic examiner and therapist. Let's say you're in a situation where you're seeing the patient in therapy. Patient has some pending legal charges. They ask you whether you'll appear in court, and you get their consent in writing, and you appear in court. And you're testifying, you know, about their mental disorder. And the cross-examination consists of, now, doctor, have you evaluated the potential for malingering? Have you done any testing? Well, it's my clinical opinion, knowing this person for 3 years. No, doctor, I'm not asking you that. Very simple question. Did you administer any tests to determine malingering? Well, no, I didn't. And you explain it's not part of a traditional clinical work. So if you were to give one of these tests, these hypothetical questions, isn't it possible that it might demonstrate some malingering or feigning or or at the very least exaggeration? Well, yeah, I guess that's possible, but you don't know that, do you? No, not in that sense. Now, can you imagine as a clinician going back into a therapy session with this patient that you've been seeing for several years, say, what do you mean you're not sure that I'm not malingering, that I'm not faking, that I'm not exaggerating? There's the end of the relationship. And the patient may very well stomp out of the therapy session. The other reason that it is different, it goes back to the thing that we just discussed, the difference between the need to reveal material if you are a therapist or if you are working under the attorney-client privilege. Okay, could we have the next slide, please? Okay, what I mentioned about psychological testing. So what, if any, testing should we be using in forensic practice? This is not as simple as it sounds. You say, well, I'll use a Rorschach, I'll use a Wechsler scale, I'll use an MMPI or a Milan or a personality assessment inventory. A lot of people don't think about the fact, and it's right in our ethics code, about normative data, about the validation of testing. And there is an ethical, I don't know if it's a prohibition, but certainly it's a guidance that you use a test only on an individual that comes from a population on whom that test has been validated. Okay, the reason for that, of course, is that there's certain norms that apply to certain groups, and that if you are using it on a different group, then the results may not be accurate. Okay, that doesn't mean that you can't use the tests at all. But when you provide an interpretation within your report, there are ethical and professional issues that you need to consider, that you need to qualify these interpretive statements. Okay, let me give you a good example of that. Okay, remember it says you use a test on the population on which it was validated and for the purpose for which it was intended. Okay. Let me give you an example, current example that is rather bothersome. You're all probably familiar with the Milan Clinical Multi-Axial Inventory, MCMI, currently in its 4th edition. The Milan, if you look at the professional manual, and if you even look at just the computer printout, it has a statement. This test was validated on a population of individuals in the early stages of psychotherapy. Any use with any other population or for any other purpose may result in incorrect interpretations. Okay, so it is saying that it should be restricted to the population of individuals in the early stages of psychotherapy. I'm sure you're all aware of the fact that it is used far more broadly than that. One of the areas that I come across repeatedly because of my forensic practice is people's use of the Milan in child custody evaluations. It should not be used in child custody evaluations, at least, the interpretive statements, because it has never been validated in a child custody population. I have read a lot of the articles recognizing this as a critique, and they say, well, it really is a psychotherapeutic situation because there is a psychotherapeutic aspect to child custody evaluations. I find these arguments less than convincing. Okay, now, does this mean we can't use these tests at all? No, we can. But you need to qualify their interpretations in light of the fact that it doesn't comply, with the ethical standard of using it only on that population. And in fact, in the specialty guidelines for forensic psychology, it explicitly points out that the same test results may mean different things in different populations, that you have to somehow take what population this person is coming from into account in your interpretive statements. So you can do this in several different ways. For one, you can actually develop, through research, separate normative statements, different guidelines. As far guidelines for interpretation, as far as I know, and somebody may want to correct me during the discussion, as far as I know, the only personality assessment available that has specific norms for forensic evaluations is the PAI. Despite a lot of statements to the contrary, I have yet to find the MMPI, or the current version of the MMPI, ever validated in forensic settings. I know the most recent version, the MMPI 3, does make reference to some forensic populations, but looking through the manual, it's been very hard for me to find them. And it does make reference to some simulation studies, but not to any known group studies. So how do we qualify? Every one of these objective tests that we use in forensic practice has what are called critical items. And I believe that any one of these tests, you can go back a second time after you've administered the test and interview people, interview your clients, your defendants, on the critical items. So, like, when you said people are controlling my movements, what did you have in mind? Okay, because on the surface, in a clinical population, it would certainly sound like a very paranoid statement. But I can't tell you, folks, the number of times I have gotten responses, oh, sure, the correctional officers, they tell me when I can come out of my cell and when I can go back into my cell. So there's nothing crazy about that, nothing pathological about it. It's a matter of the context. If you will, it's a contextual rather than a pathological interpretation. If you're doing a personal injury evaluation, someone is alleging that they are somehow psychologically damaged by a particular accident or injury, and they endorse an item, there are people following me. Doesn't necessarily mean they're paranoid, because in a lot of personal injury cases, the defense will in fact hire private investigators to follow individuals. What about in a child custody evaluation, where they endorse the item, people say insulting and vulgar things about me? Ever go into family court? You're damn right that the attorneys are going to be saying insulting and vulgar things. So always consider the context and take the context into account in your interpretive statements. Don't just quote what the computer report has to say. A few words about what are called forensic assessment instruments. And I didn't mention this as a drawback to the use of traditional psychological testing, although I use it all the time. I think it's very important to use. But remember, the psychological testing, or for that matter, a clinical interview, does not answer directly the forensic questions posed. In order to look at the forensic questions, you should use or can use what are called forensic assessment instruments. These are instruments which are developed with the specific legal tests in mind. For instance, competency to stand trial consists of 3 elements: factual understanding, rational understanding, and ability to assist an attorney. There are some forensic assessment instruments developed and validated to address those particular legal issues. You know, how does a particular mental illness, for instance, impact a person's factual understanding? How does it impact their rational understanding? How does it impact their ability to assist an attorney? So really, you need both. You need the forensic assessment instrument along with your traditional clinical instrument, because the forensic assessment instrument may say, yes, there is impairment in this area. The traditional test will tell you why that impairment exists. Okay, next slide, please. Okay, can a psychologist testify in court? Well, again, we've talked about it to some extent, the different roles, the different methodologies, and the different approaches to privilege. And all of these will impact on possible testimony in court. But we get to a sort of a conceptual difference among our colleagues. Some say, absolutely not. Under no circumstances should a therapist ever go into court and testify. There was a very interesting article a good number of years ago. I think it was by William Foote and an attorney, I forget the name of the attorney, arguing for the absolute prohibition. And this is opposed to a therapist going in and just having certain limitations to their testimony. They argue, Schumann, Daniel Schumann was the lawyer, and William Foote, a psychologist. They basically make a slippery slope argument as to why there should be an absolute prohibition, which is no matter how hard a therapist tries to avoid getting into forensic issues, say, I'm just the therapist, I have no opinion on that. Skillful attorneys have a way of phrasing their questions that almost without any willingness or intention on their part, the therapist may answer something in a way that does address the legal issue. If you go the other route, and say, yes, I will testify, but as a therapist, but I will testify only to that which is within my area of expertise, namely diagnosis, prognosis, and progress in treatment. Anything else is, off limits. If you can do that, fine. Foote and Schumann are basically arguing that it's very difficult, if not impossible, to draw those limits at all times, to totally avoid the forensic issue. Quick example, I was asked to consult on a case where a very, very intuitive psychologist who had been trained in working with traumatized kids. The father in this family had been very, very abusive. The kids had observed horrible abuse of their mother, including the father chasing her around the house with a chainsaw. Father was arrested, charged with many counts of aggravated assault, was serving time in prison. The children went into therapy with this woman. And when he comes out, consideration for parole, one of the things that he wants is to, he asks for visitation with his kids. The state is opposing it, of course, and the state calls this psychologist as their expert witness. And she says, I really can't do this. She's aware of the fact. She says, I really can't do this. I was just their therapist. All I can say is that I saw the kids, they made good progress in treatment. And yes, they are terrified of their father, but I can't answer any questions regarding custody or visitation. Fine, says the prosecutor. So the prosecutor goes through and she says, I'm just the therapist. I have no opinion on custody or visitation. And on cross-examination from the man's defense attorney, he says, well, you say the children are terrified of their father. Yes. And you believe they are still terrified of their father. Yes. Well, considering the fact that they're terrified of their father, do you believe that unsupervised visitation would be good for the kids? And she said, no, I do not. And so that means, doctor, that you are, if he had visitation with his children, it would be supervised visitation only. And she was caught for a minute and she says, well, yes, I guess that's accurate. Okay. And caught her in a moment of cross-examination. And long story short, the father and the attorney then filed a complaint with the state licensing board that she made an opinion on a forensic issue without having examined the father. So even when you have the best of intentions, it's very difficult avoiding that issue. Okay, thank you. And one final slide. Media contacts. Sure, you see psychologists all the time, a lot, being interviewed by the media. A few words, and by the way, I'll preface this with an experience a colleague of mine had, very experienced forensic psychologist. He got sick and tired of always being called upon by the media. So one time they said, will you come and, talk about thus and so? He said, okay, but I want you to be aware that my professional fee is $350 an hour. And if you send me a check for that amount in advance, I'll be glad to come and give your media interview. Nobody ever called him anymore. So that's one approach you can take. But generally, the best approach is to just avoid it for the following reason. You want to avoid media contacts regarding people that you have not seen. Ethical issues. You do not provide diagnosis, conclusions, or recommendations on anybody whom you have not examined. If we had more time, we could get to all of the issues regarding certain major political figures, and that there are always people commenting on their psychopathology in the media. Shouldn't be doing this. Okay, what about people who say yes? You should also avoid this. In fact, I saw one case where this was an adolescent boy who had badly assaulted a girl in his high school class, classmate. And then he and the attorney went on the Today Show in the morning and discussed the case, along with the psychologist's diagnosis of the young man. And my concern, even though the attorney says I gave consent, the young man gave consent, can you really give consent to a media interview where you don't really know in advance what kinds of questions are being asked? I would prefer to not do that. Okay, does that mean I will avoid these entirely? No. And in fact, the forensic specialty guidelines say, you can do it. They don't say you can't do it under any circumstances, but you can do it if there is an educational purpose underlying your media contact. What do we mean by this? If there has been some misrepresentation of something that is very important, and within the mental health area, and you believe that it's important for people not to be misled by that, that's a situation where you can go on the media. Let me give you a quick example because I see we're running out of time. Years ago, and I was in Baltimore at the time, which is where I was many years back. There was a case of an elderly individual, lived in a very poor part of the city. He was being harassed by some young tough guys in his neighborhood. They were throwing rocks, doing at his apartment. And he yelled at them, go away, or I'll call the police. Yeah, sure, old man, go ahead, call the police. Go away, I've got a gun. Yeah, sure, old man, go ahead, show us your gun. Well, in fact, he did have an old shotgun, and he had 1 or 2 rounds of ammunition in it. And he fired the gun into the air in an attempt just to scare the kids away. Unfortunately, one of the bullets ricocheted off of a brick wall and came back and killed one of the kids. He was charged with manslaughter, for not recognizing basically the riskiness of his behavior, negligent disregard of risk. And the state offered a fantastic plea bargain. Plead guilty to involuntary manslaughter. You'll have 1 month house arrest, with an ankle bracelet. And the ankle bracelet can be removed if you have to go to the doctors or go shopping or something. Sounded like a pretty good plea arrangement. but his attorney was a real publicity hound, and he wanted to take the case to court. So he got a psychologist to testify that this elderly gentleman who had no prior criminal record suffered from urban fear syndrome. So long story short, I got a call from a local television station. Will you comment about this case? And I said, I'd be glad to, but I never examined this guy. I'm not going to testify. No, we just want your input on urban fear syndrome. I said that I'll be willing to do. And so they had me sitting with the DSM, it was the DSM-4 at that time, on my coffee table. What is this volume, doctor? I explained what it is. So it's a listing of mental disorders, yes. Is there a diagnosis in there called urban fear syndrome? No, there is not. And that was the end of the interview. So that I regarded as a legitimate media interview because it was counteracting a misrepresentation. Okay, I think that's it, folks. Well, I mean, I've got a lot more to say. This is, frequently asked questions in forensic settings. I've got about 10 or 15 more questions, but let's stop for now, and I'd be glad to entertain any comments or questions.
Thank you so much, Dr. Shapiro, for that. As you can probably see there, we do already have several questions.
Sure, go ahead.
That are looking for the CEU survey. The QR code for the APA CEU survey is up on the page right now. The link will be posted in the chat box shortly. So just hang tight, look for it in the chat box in the next couple of minutes, and it will be up. David, as a heads up, it seems like some people have some hypothetical or general scenarios here that are rather lengthy. So when I read those, I will let you know what time those were posted. So if you wanted to be able to and scroll across, you can do that.
Do my best.
Yeah.
Okay.
So one person wanted to go back and clarify the citation you said about the California case that favored attorney-client privilege over disclosure. Just saying, what was that case?
It was a case. It was Elijah. Someone, I see Jeff is on the, Jeff, do you have that specific site? It was a 2014 case, I think Elijah J. against Superior Court, something of that. But it was Elijah versus Superior Court. I think it was 2014. And as I said, it's the only case that I know of that has ruled that attorney-client privilege overrides mandatory reporting.
Wonderful. Thank you for that.
Yep.
Related to that question, somebody at 11:30 said a Minnesota psychologist performing an evaluation reported that the parent disclosed having spanked a child 3 years prior. That evaluator made a child protection report during the process. It was ruled out, but left open the question of why the evaluator took the step and if it was prejudicial. This evaluator said they weighed mandatory reporting obligations over forensic client privilege. What would you say in reviewing that work product overall?
Well, first of all, I would have to say, what is the state law regarding that? I mean, do they have something similar to that Elijah ruling? The chances are not. And it's a difficult question. The way I handle it, I'll just tell you, the way I handle it is to tell people who are coming in for an evaluation at the outset, because where I am, there is no case law on that. I just take the conservative stand. I am a mandated reporter. If you tell me about this, I must report. Then leave it up to them as to whether they want to continue with the interview or not. So that's the only thing. I don't know whether this person had said that as part of the informed consent. Basically, since there is no case law on it, I am still a mandated reporter. And if you tell me about abuse, I must report it. I think that's the only way out of it. So did this person do wrong by making the report? If the complaint went to the licensing board, probably there wouldn't be any action because the board requires the mandatory reporting. Now, if whoever was involved wanted to file a lawsuit, it might be grounds for another ruling, on what takes precedence over what. But I don't think there's any, real complaint there, unless there is case law to the contrary.
Certainly. Somebody asked, what type of info is considered prejudicial at the time of writing a competency assessment? How is confidentiality handled for these types of assessments? For example, info about substance abuse history, can that be prejudicial?
Yeah, it can be, and generally, well, what is prejudicial is you do not talk in your evaluation at all about the offense. Okay. I examined a guy today who said, well, the police report says I did this, that, and the other thing, but that ain't the way it was. And then just proceeded to tell me his version of it, which was an incredibly delusional version filled with auditory hallucinations. And so my way of handling that is, in his recounting of the alleged offense, he remarked on delusional thinking and on auditory hallucinations, but didn't say anything about what he said. Even if he's denying it, you don't make any comments. So that's prejudicial. The issue of drug abuse is pretty much the same. That unless, of course, it is part of the person's history, in which case, you can report it as, part of your diagnostic impression, but you don't go into any details about what they said.
Absolutely. That gets into a whole other topic of forensic report writing and communication.
Exactly.
Do
right.
Another hour on easily. Yes.
Yep.
Yes. When working with juveniles, does your process change? This person asked specifically when considering malingering.
When considering malingering?
Yeah.
Well, that's a difficult one to answer. I mean, the most obvious answer is you would only, if you're going to do that, you only use malingering tests that have been validated on juveniles, and we know that a lot of people use tests inappropriately. I recently had a case where this guy's had a developmental disability all his life and has been hospitalized at least 15 times. And they said, no, he is malingering because he was below the cutoff. He's malingering everything because he's below the cutoff on the test of memory malingering. Okay, well, first of all, while there is some debate in the field, there's some articles that say pretty strongly you should not be administering the test of memory malingering to people with developmental disabilities. Other articles say, the contrary, but considering the fact that there's a controversy in the field, I wouldn't do it. I'm not in any position to resolve that controversy right now. So yeah, I would talk about the number one, about only if there is validated material on kids on this particular instrument. And then I guess that's the main thing, because if there are some major differences between the way juveniles and adults would answer the test, that should be covered in normative studies. So yeah, I would avoid it unless there are some actual studies that say that demonstrate that it's still valid.
And one final question, as we're a
Sure.
little short on time here. Someone said, given the concerns about the Milan, you're noting about MMPI-3 norms, what tests would you use to assess personality pathology in a forensic setting?
Well, as I mentioned, I think the PAI is the best of them because it does have norms for forensic settings, and it's, as far as I know, it's the only test that does. Plus the fact that they have got normative groups that other tests don't have. They have their trauma scales include material regarding domestic violence and sexual assault, where some of the others are just deal with war-related trauma. And they've got a variety, they've got 6 different scales that address the way a person presents themselves on a test. Not malingering, but you all know the exact words are escaping me. The way they present themselves on tests.
Response style.
Yeah, response style. Thank you.
Yeah.
So I like the PAI, which I will use in combination with obviously other tests and interview techniques.
Dr. David Shapiro. David, thank you so much
My
for
pleasure. Always
addressing all of these issues, helping us zoom out and see what, at its core, what this work is and what we're all about when we're trying to address issues in the legal system.
Thank you,
Anthony, for all your work in this field and your considerations here that you've presented to us today.
My pleasure.
Yes.
Okay.
That wraps up this week's Law and Mental Health series. Next week, we have Dr. Maria Apatero Suedo, who will be discussing competency evaluations in immigration court. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.
Bye.
Bye.